Remedies. In this short video we will consider what happens when one of the parties to a contract fails to do what they promised to do. If one party to the contract breaches a term of the contract, a statutory term, or in some cases a non-contractual representation or promise, and they're not protected from liability by an effective disclaimer, there are a number of possible legal remedies available to the other party, including 1. Rescission, 2. Damages, 3. Equitable remedies, and 4. Statutory remedies. We will consider each of these possible remedies in turn. So the first possible remedy is rescission. Rescission is an order of the court declaring a contract to be terminated or unenforceable in the event of complete non-performance by one of the parties, or breach of a condition of the contract, or a misrepresentation, or, as we saw in earlier videos, mistake, duress, undue influence, or unconscionability. When a contract is rescinded, the court will, as far as possible, seek to restore the parties to their original positions. For example, in a contract for the sale of goods, if the contract is rescinded, then the buyer of the goods will return the goods to the seller, and the seller will refund the price back to the buyer. So in relation to many contracts, the remedy of rescission means that the buyer gets their money back. It is important to note that the remedy of rescission is not always available as a remedy in the event of breach of contract. Whether or not the other party is entitled to rescind the contract will depend upon whether there has been a complete failure to perform or partial performance of the contract, and whether the partial performance involves breach of a condition or a warranty. So a party will be entitled to rescind the contract if the other party completely fails to perform the contract. A party will completely fail to perform the contract if they make no effort to perform their contractual obligations, or their actual performance is completely different to what they were required to do under the contract, or prior to the time for performance they clearly indicate that they will not be performing their obligations, which we call anticipatory breach. For example, if you and I enter into a contract according to which I am going to pay you for renovating my home, if you completely fail to show up and do any work at all, then our contract can be rescinded and I won't have to pay you. That will be a complete failure to perform. If you do show up and you do some work, but the work you do is completely different to what you and I agreed you were going to do, then again that is a complete failure to perform. The contract can be rescinded and I don't have to pay you. And if prior to the agreed date when the work was to commence you contact me to tell me that you are no longer going to go ahead and do the work, then that will be an anticipatory breach, and again the contract can be rescinded and I will not have to pay you. Many breaches of contract, however, do not amount to a complete failure to perform. Instead, one of the parties does some or even most of what they're supposed to do, but they don't do everything they're supposed to do. Or they do most of what they were supposed to do correctly, but they do one or two things a little differently. A party will partially perform the contract if they comply with some of the terms of the contract but breach one or more of the other terms. If they breach a single term of the contract, whether the other party is entitled to rescind the contract will depend upon whether the term breached was a condition or a warranty. A condition is a term of the contract of fundamental importance. A warranty is a term of lesser importance. If the party in breach has breached a condition, then the other party is entitled to rescind the contract. However, if the party in breach has only breached a warranty, then the other party is not necessarily entitled to rescind the contract, although they may be entitled to one or more other remedies. For example, in Associated Newspapers and Banks, Mr. Banks was a cartoonist who had a contract with Associated Newspapers, according to which, amongst other things, the newspaper promised to publish Mr. Banks's cartoon on the front page of the comic section of the newspaper. During the term of the contract, for a number of weeks, Associated Newspapers breached the contract and published Mr. Banks's cartoon on another page of the comic section. Mr. Banks insisted that that breach entitled him to rescind the contract and to leave the newspaper and take his cartoon to another newspaper. Associated Newspapers argued, however, that the breach of contract, which they did not deny, did not actually amount to a breach of a condition. Instead, it was only a breach of a warranty, and therefore Mr. Banks was not entitled to rescind the contract and had to stay in the arrangement with Associated Newspapers rather than move to a different newspaper. So the question before the court was whether the term according to which the cartoon would be published on the front page of the comic section was a condition or a warranty. And the court decided that the location of a comic strip in the comic section was of fundamental importance, and that therefore the Associated Newspapers had breached a condition, and Mr. Banks was entitled to rescind the contract and move to another newspaper. So the important point here is that whenever there's a breach of a contract, we should not automatically assume that the other party is entitled to terminate the contract and move on. We need to consider the particular type of term that has been breached, and it's only if it is a condition rather than a warranty that the innocent party will be entitled to rescind the contract. The second type of remedy, and one which is very commonly sought by parties who have suffered harm as a result of a breach of the contract by the other party, is damages. Damages is, of course, as we have already seen in earlier videos, monetary compensation. The other party will be entitled to damages in the event of any breach of contract, whether it's total or partial, whether it's actual or anticipatory, and whether it's a breach of a condition or merely breach of a warranty. They'll also be entitled to damages in the event of breach of a collateral contract and in the event of a misrepresentation. The objective of the court in making an award of damages is to restore the other party to the position they would have been in if the breach or misrepresentation had not occurred, that is, if the contract had been performed properly. It is important to note, however, that the other party is under an obligation to mitigate their loss, and mitigate here means minimize their loss. So, for example, if you and I have entered into a contract according to which you are going to rent my house for a term of 6 months, and 2 months into the contract you tell me that you're leaving to go and live somewhere else, then of course you will be in breach of our contract, and I will be entitled to compensation. Now, you might think that the amount of compensation that I will be entitled to is the amount that I would have received if the contract had not been breached. In other words, you should pay me 4 months' rent. However, I am under a duty to mitigate or minimize my loss, which means I cannot leave the house empty for 4 months and insist that you pay 4 months' worth of rent. Instead, I need to take whatever reasonable steps I can take in order to find a new tenant. And then once I do find a new tenant, the amount of compensation that I'm entitled to is not 4 months' rent, but rent for the period in which the house was empty, which will be, of course, much less than 4 months. And if the tenant is paying rent at a lower rate than the rate you were paying, then I will also be entitled to the difference between the two rents. The third type of remedy that is available in the event of a breach of contract are the equitable remedies. We talked in the earlier topics about the remedy of injunction, but here we will talk about the remedy of specific performance. An order of specific performance is a court order directing the party in breach to fulfill their contractual obligations. So, for example, if you and I have entered into a contract according to which you are going to purchase my home, and then after we have signed the contract, I change my mind and decide that I don't want to sell it to you anymore, you can sue me for breach of contract, and the remedy you seek may, instead of compensation, be a request for an order of specific performance, and that would be an order of the court directing me to fulfill my contractual obligations and sell you the house. The fourth type of remedy available in the event of breach of contract are the statutory remedies. So if the term breached is one of the terms implied into the contract by the Sale of Goods Act, for example, the legislation itself provides a wide range of remedies. We will be looking very closely at statutory remedies in Topic 7.